Hello, and welcome to another issue of Coffee Talk with immigration attorney Brian D. Lerner. This, for now, will be the last in the series on the executive orders issued by Trump over the last week or so. I've done videos on the other ones, and until another one is issued, this should do it at least for today. So at least it gives you an idea of what the executives are, how they work, how they can be fought, and so forth. Now, the last one is entitled "Enhancing Public Safety in the Interior of the United States." But the problem with this one is, minus the fact that it's vague and ambiguous as to how it's supposed to work and how exactly it's supposed to be applied to the everyday person walking around the street, there are some very disturbing issues that we need to talk about in this executive order, and it is very likely that if the provisions of this executive order are in fact put in play, that there will be lawsuits all over the place as to the constitutionality of the provisions and so forth. So, one of the issues that it talks about are, quote, sanctuary cities. And it basically states that if these cities essentially do not enforce the immigration laws, and the bottom line is do not try to deport the people who are there illegally, then the federal government will not fund and will stop funding basically anything that comes down the line of that particular state. So let's look at that for a minute and let's analyze it a little bit in regards to that. Now, when you're looking at what the president calls sanctuary cities, it happens to be border cities. That's the reality, because that's where a lot of the immigrants have come in and have either gone out of status or are not here legally. And obviously, you're talking about California, Texas, Florida, New York, and so forth. And so the issue then becomes is how those states, how are they supposed to enforce the immigration laws? Now, immigration law is federal law, it's not state. Okay, all of the statutes cited by immigration law, all of the cases, all of the regulations, it's all federal. Okay, it's not state. So a state policeman does not have the realistic authority to stop someone and say, show me your immigration papers, because of a couple reasons. One, it's profiling, which is a whole other issue. But secondly, um, the state police are basically being asked to do the job of the federal government. So there are clauses in the Constitution of where the authority of the federal government ends in regards to the state, what the state is allowed to do and not to do. But essentially, the Constitution is not going to provide or be able to mandate that the federal government can order a state to do what is under the laws a federal item, and that's all of immigration. So the executive order essentially states that the sanctuary cities are going to be punished for not complying or enforcing the federal immigration laws. Well, first things first, the immigration authorities, CBP, ICE, USCIS, AAU, BIA, EOIR, all of these sub organizations of immigration law under federal law, they are the ones who are charged with enforcing the U.S. immigration laws. You can't just, you know, pile off those duties onto state officers. That just won't work. So, on one ground, the lawsuits, I'm sure, are going to go forward probably from the states themselves against the federal government in regards to the request that they essentially start taking up duties of the federal government. So that's the first big issue with that I see with this executive order. Now, next, and I'm not going into all of the different provisions here, just the couple big ones that have the issues. So it says that Homeland Security shall prioritize for removal, and it lists various code sections. Uh, but then the problem part comes with and as well removable aliens who A, have been convicted of any criminal offense, B, have been charged with any criminal offense where such charge has not been resolved, or C, have committed acts that constitute a chargeable criminal offense. So we have some major problems with this. Okay. Um, First of all, when it says that as well as removable aliens who have been convicted of any criminal offense, well, any criminal offense is, can be stealing a pack of gum, all the way up, of course, to murder. So the current immigration laws take into effect all the items which make someone removable, and it lists under the code sections all of the various crimes that will place someone into deportation proceedings. So there are lots of crimes that people can commit that essentially do not make them removable. Okay, so that's the first issue. So when it says any criminal offense, that naturally is extremely vague and extremely overbroad in regards to that particular provision. Now, next is even more troubling. It says, have been charged with any criminal offense where such charge has not been resolved. So, what does this mean? If somebody has been charged with a criminal offense and they believe they're innocent, which the law does say innocent until proven guilty, that immigration is going to come into court and going to take those persons out of court and deport them because they are in the midst of proving that they are innocent, or put another way, the other side is in the midst of proving that they're guilty. Um, what happens if they go to court and they are found not guilty? This executive order doesn't take that into account. It essentially says if they have been charged with any criminal offense, they're guilty. That's basically what it's saying. It's saying if you don't happen to be a U.S. citizen, then you are guilty before you are proven to be guilty. You are presumed to have been guilty. So, of course, there's big constitutional issues with that particular provision. And next is even more vague. If you can believe it, it's even more ambiguous. Is C, it says, have committed acts that constitute a chargeable criminal offense. Well, how's that going to happen? How are they going to deport people like that if somebody hasn't even been charged with anything, let alone that they have or haven't been found guilty? They haven't even been charged. That essentially gives the right to, I mean, I'm just aghast how this would work. Does this mean that if an officer sees somebody and believes that they have done something which is against the law, that they can just take them, report them, and deport them? It just doesn't make sense. So uh, that's the reason we have immigration laws on who can be deported, what crimes make them deportable, what the elements are of removability. It's all spelled out in the Immigration and Nationality Act. To take something like this executive order, and essentially just open Pandora's box and I mean, really, what it's doing is just give authority to just deport anybody that they feel they want to, without any evidence, without any actual conviction. just goes completely against the principles of the Constitution and of the United States. So I'm quite certain that there will be lots of lawsuits that will be filed on those particular provisions should the enforcement attempts be made to deport people who essentially are in trial and or have no convictions or are convicted of something that doesn't make them removable. So either way, that will conclude the series for today. If you have any questions, of course, give my office a call and I'll be happy to help. More in the coming videos.